Welcome to the Sarachek LLC video series on specialty finance and litigation funding. In this series, we discuss hot topics in legal funding and related asset classes. Today's focus is on funding in the bankruptcy and receivership context. I'm Evan Freed. I'm a partner at Sarachek LLC. We are a New York-based litigation boutique. I've had a footprint in the litigation finance space for over 15 years. We litigate an array of disputes, and a bunch of them involve litigation funding in some form or fashion, everything from investment disputes, legal ethical disputes, and disputes pertaining to litigation finance contracts. We also do quite a bit of hybrid and contingency work, including judgment enforcement actions, and that frequently involves considerations of litigation funding. We're joined today by two experts in the field, Lee Buchwald and Joe Sarachek. Lee and Joe, could you give a brief intro on each of yourselves?
Sure, Lee. B comes before S.
Okay. Well, thanks very much, Evan. Appreciate the opportunity to participate in your wonderful series. I've looked at your earlier productions, and they're really quite informative. I am Lee Buchwald, the president and founder of Buchwald Capital Advisors. I founded the company in 2001 and 24 years and still going strong. I focus on financial advisory and fiduciary assignments in bankruptcies and restructurings. I've served as a Chapter 7, Chapter 11, liquidation, trustee, as well as a CRO, independent director, and corporate officer. Prior to my founding of this company, I was a managing director at Rothschild, went on from there to Solomon Brothers and Channing Capital Partners, and then started here. Joe?
Thanks, Lee. So I'm Joe Sarachek. I run the Sarachek Law Firm, which is a contingency fee law firm that focuses on bankruptcies and restructurings. We only represent investors and creditors, and on a contingency fee basis. So just to give you a flavor, that means we're very focused on good litigation opportunities, good recovery opportunities. We also separately have a fund called Strategic Liquidity Fund that buys judgments and looks at a tremendous amount of commercial litigation opportunities, portfolios, and such. I am in the end process, hopefully closer to the end than the beginning, of writing a book called The Distressed Investing Playbook. It's based on my 6 years teaching at NYU Stern. I love all things bankruptcy and restructuring related. And a lot of people know me as the claims guy, meaning bankruptcy claims. I've traded in excess of $3 billion in claims, meaning bought and sold. And claims by its nature focus on litigation opportunities.
Am I on the mailing list for the textbook with the signature and all?
100%, but in these days, as you know, most things are digital.
Touche. I'll take the NFT of the book. That works too. So what are each of you guys working on right now? What's a good example of a current project?
Started focusing on the real estate sector. I find that there's quite a lot of opportunities there, and those that are well suited to a firm of my size. So I'm currently working on a project, a multifamily development project in Brooklyn, a restructuring and redevelopment of a office park in New Jersey, and a build out of a high-end restaurant in Manhattan that's under construction. So those are areas, particularly they happen to be in the New York area, so they're very well suited to my type of operation, and I hope there will be more opportunities to pursue.
Joe, what about you? What are you working on right now? Always something.
Litigation, litigation, litigation. All right. So a couple fun things that we're working on. A big law firm brought us in about a year and a half ago to pursue a $13 million judgment against the senator from West Virginia, Jim
Wow.
Justice's companies. And he's the senator who he was the governor. He always appears with a bulldog in his hand. He's, I think, 6'8" and 300 pounds. He's a larger than life character, but he doesn't like to pay his bills. He owes $1 billion, and the old adage that the more you owe, it becomes somebody else's problem. We were brought in because to get that $13 million judgment cost about $3.5 million in legal time. And the client finally said, no more.
Mhm.
Let's find someone to do this on contingency. Perfect situation for us. Within 6 months of coming in, we had grabbed the company's helicopter and sold it. A lot of my friends wanted a ride on the helicopter before we sold it. And honestly, I thought I was going to get a ride. But that was an interesting, what we see in general is it's easy to get a judgment. It's very hard to enforce it. It's very hard to get money. There we got almost $1.5 million. And, we actually had to go into court to attach the helicopter, and helicopters are obviously regulated by the FAA, and they're in Oklahoma, and it's a whole process. But we know how to navigate around the country enforcement of judgments. We have about 75 lawyers working for us on a contingency fee basis. Obviously, it's New York, Florida, Texas, California, the major places, but we'll go in other places as well, Las Vegas, and so on and so forth. So that's one matter. Another matter is sort of more run-of-the-mill. We're representing a Chapter 7 trustee in a fraudulent conveyance suit against American Express that involves $18 million. It comes out of another colorful scheme, a sneaker fraud that started in Oregon, obviously where Nike is based. The particular debtor in this case, which is located in New Jersey, was a major creditor of that fraudster. And Amex was all over this, and we're pursuing them. So that's another matter. More recently, like in the last couple weeks, we've been involved in the Liberated Brands case. We sit on the creditors committee with our client, and there too, and this leads into the subject matter of this, the controlling shareholder there is Authentic Brands Group, led by Jamie Salter. And there are allegations that he took out a significant amount of money. And guess what? That's a litigation claim, and one that people are sizing up as we speak.
Awesome. Well, look, the real reason I wanted to have both you guys on, or each have a real specialty in not just the core of the litigation or the bankruptcy or receivership proceeding, but it's really how to fund the costs and how to deal with the realities of often substantial budgets on these. Litigation funding in the general commercial context, if one were to go to Burford or Omni or Stratera, is relatively novel the past 10, 15 years here in the United States. But for bankruptcy or insolvency practitioners, these are things that y'all have been talking about in various forms or fashions for decades upon decades. Lee, let's start with you. What is it about the bankruptcy or receivership process that forces practitioners to think about, not just what are the steps, but how we're going to fund those steps of whatever process it is?
Well, it starts out with no money. When you have no money, you got to find a way to do stuff. I literally can't recall any case that I worked on where I actually had money. So it leaves you, it leads to, in order to find a way to pursue litigation, you have to either find contingency counsel or find funding. And there are hybrids of that. I know you have a lot of experience in that area, but that's really what it's about. If there's no money there, but there's a valuable claim, we need to find a way to get to it.
Lee, your big case against the steel guy, was there no money there?
No money at all. That was the Magnesium Corporation of America case. The company had filed for bankruptcy, and I had come in as the Chapter 7 trustee, but by the time I came in, the business had been sold, actually sold back to the company Renco Group that had bankrupted it. So there was no business. There was a little bit of cash in the bank, but not enough to, to buy a roll of postage stamps. It was literally essentially a no asset case.
Hey, Lee, can you set that up and tell us what was the size of the unsecured creditor pool there?
It was around 120 million.
So they were looking at a zero when you came in.
They were looking at a zero.
I mean, look, just for the rest of you, like, Lee's a hero in this game. I mean, no, you are. Come on, Lee, you're being very modest.
Oh, thank you.
How long did the whole thing take? You were fighting a behemoth, and like, what made you think you could win? What was the setup that kind of early on you said, this is a winnable case?
Well, was it a winnable case? That was an interesting question to begin with. We had, as I said, no money. We had to find contingency counsel to do the litigation. And again, because there was no money, we had to find contingency counsel that was willing to fund not just the legal part of it, but all of the expenses, literally front everything. And this was a hard-fought litigation against a billionaire who, essentially had a bottomless, endless amount of, sorry?
Unlimited resources.
Effectively, yeah, unlimited resources. And early on, it was not clear that this was going to be a winner. It was actually not easy to find contingency counsel that was willing to take on this kind of litigation against that kind of defendant and fund the expenses as well.
And
So,
fast forward.
So, I got to draw this out of him. I'm sorry. And we're friends, Lee and I. Lee, how much did you recover in the end?
In the end, the recovery was $213 million.
And what was the contingency fee?
It was about 34%.
Jeez, wow.
How
many years did it last?
13 years.
Wow. Really just, it's one of in bankruptcy annals, it is really one of the most amazing verdicts, period, end of story. And, Lee and I know each other personally, and I just can't believe, I'm an impatient guy. I really am. And I'll just.
It's true. That's actually true. Yes.
I'll juxtapose that to something that I did this summer. We represented an ad hoc committee of 1,900 creditors in the Celsius case, and we got between 75 and 100 million, but it took us 6 months to get that. I just wouldn't have the patience to wait 13 years. Now, that too is a form of litigation financing, because that's what we're really talking about. And by the way, I want to pop the Sklarski firm. I met Evan several months ago, and I'm really, really impressed by the caliber of the attorneys, and in particular, Evan, just whip smart. And if folks are listening to this, that should be your first call. Not Sarachek Law Firm, Sklarski.
Really, Evan, how much did you pay for that?
I'm saying that.
You know what, guys? I couldn't get better at advertising. This is unbelievable.
you guys are whip smart. You're like no nonsense. You have big firm infrastructure, and that's important because when you're litigating, and I just want to tell you the story of the Celsius. So we're up against Kirkland and Ellis, the biggest, the best, really quality firm. And at the outset, when we came up with this legal theory, which was that they violated the plan of reorganization in the treatment to our clients, they said straight up, we're going to crush you like a bug. And I said, all right, you'll crush us like a bug, but then we'll appeal. But the point is, when you're up against big firms, they probably had 10 people on the matter, and I had 3. Now, the benefit is I have 30 years of doing this and some deep sophistication in this, but effectively, I had to finance. Sarachek is financing this fight, and that fight can get really expensive. And, so I know what it cost for, let's call it 6 months of this. And I say 6 months because in March, we sort of analyzed that there was a violation. We ended up filing a motion. I think we filed it in June. We went to 2 days of intensive mediation, which was our request, in August, and it was approved, let's call it, in September, and distributions were made in early November. The point is, 13 years, that is some battle. I mean, now, just looking at it, Lee, the dynamics of your battle, if it weren't Ira Rennert, a man who's a billionaire, might have been different. If it were, let's say, American Express or some other corporate entity controlled by a big board, at some point they may have said, you know what? All right, maybe not 200 million, 100 million, 50 million, some number.
Well, the interesting thing, or the actual claim was in the $100 million range. The reason it got up to the 200 million range was prejudgment interest.
Sure.
So the time prior, the time that the bad actions took place was a span of 10 years, at least. I don't remember the exact. And during that period of time, the interest rates were actually pretty high. They went down later when the Fed changed them, but the interest rates are pretty high. So a lot of, basically half of the recovery was prejudgment interest. We got some post-judgment interest as well. But yeah, you're right. It's different from litigating with a company. Ira Rennert, who is the controller and owner of Renco, had an ego. He was an individual, not really a company. And there were opportunities along the way to settle for a whole lot less money than what he ended up having to pay. But either his own ego or maybe his lawyers were pumping him up. I don't know, obviously, but there certainly could have been a much better result for him and in a much less time. But if your opponent of the litigation wants to keep fighting, they want to keep fighting.
What about the actual monetization transaction that you guys struck at that time? Can you walk the viewers through that?
Sure.
Thanks.
So we won the case appeal at the Second Circuit. The defendants requested en banc review of the decision, which was denied. But prior to the decision, we had a period of time after it was fully briefed, but before the hearing was held, and which, as I said, we ultimately won, but of course at the time we did not know that. So we had the victory at the district court. We had a fully briefed appeal at the Second Circuit, which had not yet been heard. At that point, I decided to monetize the potential victory, which would have been, as I said, in the $200 million range. And as had been the case through the entire litigation, I still had no money. I probably even had less then than I had to begin with, because of probably some expenses along the way. So the idea I had was to sell a piece of the upside of the litigation and to sell to a litigation funder. And at the time, litigation funding in general in the US was fairly new. I mean, it had been around, but kind of in the shadows, and it wasn't really well either understood or utilized, and particularly even in bankruptcy, maybe it was more so in other types of litigation. And I was curious, I actually looked it up. There was about 1.8 billion of litigation finance in place in the US by the four largest litigation finance companies at that time. The number now is probably in the tens of billions. So it was a new idea, and it was a very novel approach to trying to take advantage of that situation. So the way I set it up was to have a sale of this upside in bankruptcy court in a 363 sale. So the typical 363 sale in bankruptcy is an asset. That's an operation, a factory or something like that. So this was really odd, just because it wasn't even something tangible. It was something which was not only intangible, but it was really difficult to value. So what I decided to do was sell a $50 million piece of the upside. That would have been, it was essentially a quarter of the hope for successful result. And I contacted a number of the largest funders to see if they would be interested in participating. And in fact, they were actually very excited to participate in this. And they was particularly interesting in doing this was that for litigation funding, which in general was pretty, as I said, was kind of unusual and under the radar at the time. In this, because it was in bankruptcy court, everything was open. The funders, the funding agreements are typically totally confidential between the parties. But in bankruptcy court, everything was had to be in the open. So we had an agreement. It was actually with Gerchen Keller, which was later bought out by Buchwald Capital, who became a stalking horse. And their agreement was open and subject to higher and better. In this case, was a little more complicated than just saying you bid 200 million instead of 190 million or something like that. It was because the terms are pretty complicated in a litigation finance. And ultimately, they prevailed, won the auction, and paid 26.2 million to get a $50 million recovery.
Thanks for fleshing that out. I mean, look, I remember that quite well. It was all over the legal periodicals. Anybody who was kind of a student of litigation finance at the time was studying that case study. Joe, do you want to talk about, and that was obviously on the way end of the spectrum of creative, even today, but certainly at the time. Joe, you want to talk a little bit about 1.0 and where we see avoidance actions funded in the bankruptcy or receivership context, and what that core transaction looks like?
Sure. Let me just also say two cases I want to mention where there was litigation funding, maybe not that widely known. One was Madoff, and it wasn't the funding of Irving Picard, who was the Madoff receiver, but Fortress quickly figured out that some of these trustees or fiduciaries of feeder funds needed funding, and they did do that, and they made gazillions. And, my hat's off to Brandon Bear, brilliant guy who runs his own fund now, but he was running point at Fortress at the time. And second, a case that I was particularly involved in, I traded almost $1 billion of debt in Stanford International Bank. And there, the joint liquidators who were in Antigua, they actually borrowed money for their suit against TD Bank. And let's just talk about like sort of basics. And I'll tell you about a trade I was involved in with litigation funding maybe 10 or 15 years ago. A guy had a judgment for, let's call it $6 million. He had no money. And of course, the judgment was being appealed. And let's just put it on the table that appealing judgments is very difficult, very low probability, but it can take some time. He needed money. He basically borrowed $2 million and in return agreed to pay $4 million. And that's a very simple, basic type of, one-on-one transaction. Many of the funders don't like to do those transactions anymore because they're called binary transactions. If you lose and there's no recourse, and in most litigation funding, there is no recourse, you're out of luck. You've lost your $2 million. In that case, of course, the guy had set like a timetable. So the sooner that the judgment was resolved, the less he paid toward the $4 million. And what that does is that really encourages settlement and other tactics like that for the plaintiff, for the guy who's borrowing the money. In that case, he basically paid back the money. He did pay $4 million. And, so it cost him on a $6 million judgment, $2 million essentially, but he did get the money pretty quickly. Okay, now to talk about what you want to talk about, which is avoidance actions. So obviously one of the main assets, or some of the main assets in bankruptcy cases, are preference recoveries. And those are 90-day transfers usually, but they can be, if there's an insider, up to 1 year, and fraudulent conveyance. And that's a very, very popular, when there's no assets, to look at fraudulent transfers is a major source of recovery. And by the way, we should also just say, Lee, as you know, many of these cases, let's call it the majority of the big cases, because of hedge funds, because of how expensive bankruptcy is and how long companies wait before they file, there are no assets.
Absolutely.
For creditors. As opposed to, Lee, when we started, and I'm not dating ourselves too much, but when we started, most cases would have some unsecured level of recovery.
Absolutely. Yeah.
And
it's different now.
Much different. You would see in the old days, Chapter 11 cases that would have, a 20% recovery, a 25, 30, 40, whatever it was. You'd rarely see a par recovery, 100% recovery. At any rate, back to what's going on. So essentially what you have is you have a couple of firms that just specialize in preferences, and one of them is a well-known firm, and they basically do this on contingency, small contingency fees, because they're looking for mass volume, and they're effectively funding, if you want to call it that, and they may have funders behind them. Many of them do, but that doesn't have to be disclosed. And then you have firms like ours, Evan, your firm, my firm, and many firms like us who will do fraudulent conveyance work. And it's expensive, it's intense, it requires forensic investigators and accountants, and it certainly takes time. Kirkland and Ellis in Celsius. We set it up so much that the judge basically said, clean this up, fix this. That's what he said. In that case, what we were focused on is a mechanism to deal with the damages. And that's why we suggested mediation. We had Judge Bentley, and even our mediation, we had extensive briefs. We had everything lined up. There is no doubt in my mind that we would have won. In this case, it was a motion. Obviously, in bankruptcy court, motions are like complaints. But just asking you, Evan, I assume you think just like me, which is until I win summary judgment, I got nothing.
Yeah, I mean, look, litigation is inherently irrational, right? You generally have a defendant on the other side who, either for liquidity reasons or because that person is a wealthy or not so wealthy, irrational person, they don't feel forced to, they have a very difficult time grasping reality, right? And very often there's delusion on the other side. Yeah, every defense lawyer likes to come in and say, let me go beat up the other side for a year or two, force them to get past summary judgment, and then sit down and settle. And there's some merit to that, right? If it's not clear. But it puts the plaintiff's lawyer in a rather challenging situation. Joe, you and I are both, hey, let's get down to brass tacks people. I think all three of us, because we've been around so much litigation and we truly think about the investment hypothesis of how much is going to go in, how long is it going to take, what's the realistic recovery, and what is the risk-weighted probability of getting these things. We do these things in our head and probably provide them to our clients all the time. We like to get down to brass tacks, but there's something about the litigation process and the fatigue from that on both sides that kind of has to run its course in order for all interested parties, the defendants, the plaintiff, the trustees, the lawyers, the judges, to really come to that point of saying, hey, this is what it is. I mean, we like to think that we could just throw a litigation claim into an algorithm and spit out what the right result is. And, we can all do that in our head, but there's something about that process, the expense and the fatigue of that process, that does make justice run. And that's the system we've set up. And it's, it has been criticized as rather burdensome, but it does work in most regards.
Evan, it's interesting. I'm the only one on this podcast that's actually a client, not an attorney. So I actually have a different perspective because I'm hiring attorneys, and typically, well, I'm not the defendant. I'm usually the plaintiff. So I obviously see both sides of what's going on. I'm being advised by my counsel, but I have no emotions in these cases.
Yeah.
I'm just essentially representing creditors, and I hear the advice of when to settle. I hear the advice of when to continue litigating. And just to be clear, Joe, I wouldn't accept advice to settle, day one or day three. No, you have to get down and dirty for a while and see how it's going. Interesting thing, though, how litigation finance comes into some of these situations. The funders actually are an interesting check on the value of going forward with the litigation. And as the client and the representative of creditors, I don't want to bring a case that I'm going to lose. And having a funder come in and check the case out, there could be a information room, and they're putting their money or their investors' money on the line. They're not doing so unless they think there's a high chance of winning, which is exactly what happened in the MagCorp case. So it's a side benefit, but I think an important one for the fiduciary to have that that kind of oversight, because frankly, if they didn't want to fund it, I'd have to question whether it would be worth going forward to, to pursue litigation.
Lee, that's a really excellent point. Yeah, I mean, even us, and I'm sure you too, Evan, we have in cases had funders look at it, not to waste their time, but to get a sense of how much, how good they thought the case was and what they would charge. And candidly, often the funders are just way more expensive than you or I, Evan, or can bear. They take away all our, I mean, if we're working on a 33 to 40% contingency fee, which I think it's important to outline it for the audience. Look, to get a demand letter and get an attorney to do a serious workup of a file, they have to charge 10%. They cannot charge less than 10% just because, one, it's an undertaking to do a real workup. But then once you go into litigation, you're up to either 25 or 33%. And then once you go to trial, you're in the 40% plus expenses range. So it's important to put that into context with funding. So if the attorney costs 40%, you can't then afford to also litigation fund at, let's call it 2x or 3x. It's too expensive. There's nothing left for the estate.
Right.
Yeah, I mean, there's a tremendous gatekeeping function, both in, having contingency fee lawyers look at these claims, figure out if they're really worth bringing, and then also the litigation funder saying, okay, no, I'm a no because this thing just isn't worth it. There's not enough juice to be squeezed here. Or you can go and do it, but I'm going to eat up all the returns out of this thing with greater of 2x or 50% of the upside. It's good. We've covered a ton of space today, everything from contingency fees, the funkiest, most creative injection of litigation funding after many years of litigation in one of Lee's cases, one of the kind of seminal cases in litigation finance, and everything in between. Why don't we just have some concluding remarks here? How do you all think that the market for contingency fees, litigation funding, fee considerations in the world where you guys play in bankruptcy and receiverships will continue to evolve? And what do you hope to focus on in the next months or years?
I do believe that since the concept of funding has gotten much more visible, there will be a continued use of it in the bankruptcy arena. A number of the largest funders, literally put that in their promo material. That's something that they do. That's something that they want to do. And I think that will continue to be the case. The estates are what's left of the estates for the unsecured creditors are, as Joe pointed out, they're certainly not getting larger, and there's all the more need to continue to have a source of funding.
How about you, Joe?
Yeah, no, I think what's really fascinating about this is, as being like an early, expert in trading in claims, bankruptcy claims, this is the next sort of iteration of financing in bankruptcies and distress. And I think it's a good thing. The market is showing you whether there's value or no value. And there'll be little guys or smaller funders, and there'll be, bigger funders. Toward that point, Fortress just announced they're another $1 billion fund. They wouldn't be doing it if the opportunity isn't there.
I agree.
Yeah, for sure. Guys, thank you so much for joining. Look, it was a fantastic conversation. Two true experts in the space covering similar, but that also vastly different experiences and situations within the space. So thank you guys again. Viewers, thank you for joining us on our video series on litigation finance and cost funding type issues. And we'll see you next time.
Thanks very much, Evan.
Thanks, guys.